Back to closing arguments. I'm Ted Rollins in for Vinnie Politan tonight. We're beginning this hour with the latest in the Parkland school massacre penalty phase. And on the stand today was Sergeant Raymond Beltran. He did not actually not testify about the massacre at the school, but rather he was there to talk about a fight that he had with the defendant, Nikolas Cruz, that was initiated in jail. Let's take a listen to what he had to say.
Mr. Cruz is walking around doing his exercise like normal. At one point here, he's gonna walk around and he's gonna flip his shower slides, where he brings them in and he walks with his shower slide folded. So I told him not to do that because I didn't want him to fall. Right here, if you want to stop it. That's when I told him. He turned around and asked me, or told me that his shower slide was broken. So I advised him that he needed to go back inside his cell, and I was going to get the sergeant on the floor to come over and bring him a new pair. And once the sergeant did that, then he can come back out.
Okay.
If you want to pause it now, at this point, he basically stopped talking, he flipped me off twice, and then he attacks me. You can start it. All right, if you want to stop. Right here, I'm trying to take control of him, but if you can see, his right hand is going for my taser. He's going for it right there with his right hand. He also grabs with his left. You can see he's trying to press the button. Right there, he has the taser in his right hand. At this point, like, I have to get the taser back.
Why?
He can tase me, he can incapacitate me, and he can basically do whatever he wants to me. We're fighting for the taser right now. At one point, you're gonna see a light, and I'll show you. Right there. You can see the light. You see where the table is? You saw the light?
Yeah.
Well, you can see the light. Basically, the taser activated. If you want to stop it. Prior to this, basically, the taser was activated. I can't tell you if I pressed the trigger or if Mr. Cruz pressed the trigger, but the taser deployed,
right,
meaning that the two prongs in the front shot out. So right here, basically, he got in a fighting stance, I got in a fighting stance. He took a couple punches at me. He missed. I hit him one time. I had the taser in my hand. I struck him. He moved back, then he got on the table. I told him to face down. I put the taser on his back. I handcuffed him. I took him back to the cell and...
Okay, that was the end of that?
Yes, sir.
Okay.
Let's bring in Court TV legal correspondent Julia Janae, who is in Fort Lauderdale, Florida, covering the trial for us. Let's start with the reaction in the courtroom to that. I mean, it's dramatic video. We've seen it before, but getting the play-by-play is something entirely different.
Right, getting the play-by-play from the man who is in that video with the inmate in this case. I've seen a lot of things out of this gallery. Mostly it's sadness, it's shock, it's sorrow. Today, you didn't see that when you're watching this video. No empathy for this inmate who's eventually taken down by the officer who is on the stand. Maybe even some smirks while watching it. We noticed from those fathers in the gallery, that's Max Schachter there, who's the father of Alex Schachter. We also saw in the gallery today Tony Montalto, the father of Gina Montalto, another 14-year-old who was killed in this horrific case. He actually spoke to us today, and there's another clear picture that these jurors got today when it has to do with the defendant. That video is pretty clear in terms of what we could see about his movements that day. Is more clear than the surveillance video of what happened in Parkland, what happened inside of the school that these jurors have already seen. They also got a much clearer picture from the words that he wrote online over and over again. We saw those introduced through a crime scene detective who had his phone and was able to talk about all of the obsessive nature type messages that had to do with killing people and hating people. And Tony Montalto in the gallery today watching that, saying that that was difficult to hear, knowing the red flags that have to do with cases like this, hoping that it encourages people to speak up and even talk to law enforcement if they see something like that. Here's a listen to part of that interview with him today.
It's just another part of the process that will be completed. We know that more than likely there'll be some appeals to this. We also know that the same place we were when we started this, with our children or our spouses being gone and the shooter being in jail. That's where we'll be at the end of it. Some families may find some closure in it. For my family, we know that we can never get closure because our beautiful Gina Rose is gone.
Do you ever look over there at the shooter's table at all while you're sitting in the gallery?
It's hard not to glance over occasionally, especially when you hear such horrible things as we saw today presented.
Again today, hearing those words from the defendant, but also hearing autopsy reports for another of the slain victims today, Ted.
That's when we've seen reaction from all week from those. I can't imagine what these parents are going through. They're there, though. They're there when they're watching the photos, the autopsy photos of their loved one, their daughters and sons laying there dead, mutilated by this massacre by this defendant. What about that? And the forensic pathologist today, what was the reaction? We've seen it all week. It's got to be very difficult. What's it like to be in that? Because it's coming through the television, the emotion. I can't imagine what it's like inside that courtroom.
Ted, it's horrifying. It's heavy. Emotionally to be inside when these medical examiners are going through the details. I will point out that the court has limited what the gallery sees, so those parents aren't subjected to seeing autopsy photos, but they hear it, and it can be just as painful hearing these details. But the chief medical examiner on the stand today with a pretty impressive background. He's not only a medical degree holder, but also a law degree holder and was active duty in the Navy, but he talked about why this particular gun and the bullets used caused the kind of damage that they did on these bodies compared to different types of weapons.
On a handgun, they usually travel around 1,200 feet per second. The bullet does. They vary a little bit, but with these types of this type of munition, it's a very small bullet. It's a .22 caliber bullet, but it's moving at over 3,000 feet per second. And so as it enters the body, it causes this temporary cavity around it, but there's so much energy with these bullets. And so it just tears skin, bone, organs for 20 to 30 times bigger than the diameter of the actual bullet as it imparts its energy as it goes through the body.
Ted, I've seen those autopsy photos, and I can tell you the entrance wounds do look very small, almost what you would imagine the size of a bullet to be. Then when the other side of the body is shown where those exit wounds are, there are holes that are golf ball size out of flesh, almost looking hollow because of the destruction it caused inside of those bodies. It is horrific to look at, and that's what these jurors are subjected to every day.
Yeah, it is a long road. Any idea of how we're doing schedule-wise when the state's planning to wrap their case?
Now, we're getting a better sense. We know that they are expected now to rest their case by the end of next week. That jury view should be happening. And we also just got an order in the last hour or so that the judge put on the record denying the defense request to have a 45-day delay. They asked for that at the beginning of this trial. They had an issue with an expert that's supposed to go over fetal alcohol syndrome who can't make it, and they need to get in a new expert. But she told them they have 1 week after the state rests. If they rest at the end of the week, so they'll have that following week off, and that should be plenty of time for them to get their expert together so that they can begin their case. So we know at least two rather, that their autopsy reports have not been gone over for this jury, so they have that still ahead in that evidence that's going to be presented by the state.
All right, Julia, Janae, thank you. Tough assignment, that's for sure, covering this trial. Doing a great job. Appreciate it. Let's bring in our think tank joining us now tonight in Atlanta, Georgia. Criminal defense attorney Eklund Mercy in Los Angeles, former federal prosecutor Nima Rahmani, and in Phoenix, Arizona, the attorney who represented Miss Jodi Arias and the author of the book series Trapped with Ms. Arias, Kirk Nurmi. Kirk, I want to start with you. I watched you in action during a death case. You were successful in sparing the life of your client, Jodi Arias. It's one thing to listen, and what we're doing now is listening to what he did. Coming up during the defense case, it's all going to be about him, not what he did, but him and how he got there. So for people watching thinking, oh, this is a slam dunk, this is horrible, he's going down. Death cases are very different, are they not?
Well, death cases are never slam dunks because it has to be unanimous. It has to be a unanimous jury finding in favor of death. And the defense is obviously going to do whatever they can to convince one or more jurors that this is not the appropriate penalty. And you're right, Ted. Once this emotional and powerful testimony, but it's never going to completely go away, it does shift to him, and it shifts to his life. And it shifts to his life not only from, what he did, but the time of conception to the time he is sentenced. And we just heard Julia talk about the fetal alcohol expert. The jury's going to hear all about everything in his life, everything he suffered, everything he endured, and they have to do that. They have to give that meaningful consideration. So I'm surprised to hear that the judge cut off this request to continue it, because that could be one of those things that get overturned on appeal. This is the first word, not the last. This is a delicate process, and the defense, in my opinion, should be given plenty of leeway to present their case.
Nima, do you agree with that? Because it's an automatic appeal. Should the judge have allowed the defense a 45-day break in trial?
I wouldn't have, just because the jury's already impaneled. But I agree with Kirk. I mean, you're going to get them those mandatory appeals, not just state, but federal, right? Because it's a capital case. So the defense is doing what they have to do. I mean, this is the most heinous mass shooting in American history. So, they are going to try to maybe pick off one juror, try to spare Nikolas Cruz's life, and if not, do everything they can, raise every potential appellate issue, because that's what capital defense lawyers do, because they know they have a much better chance on appeal than they do with these jurors there in Florida.
Eklund, he pled guilty, and he was willing to go life without parole. Your thoughts on the decision made by the state to move forward with this? A lot of expense to the state of Florida, a lot of agony for these families that doesn't end here, even if he's sentenced to death. It's years and years of appeals. Your thoughts on the overall how we got here scenario?
Well, personally, I, as an attorney, I don't believe that they did that they made the right decision. I believe that Nikolas Cruz should be studied. I think that we need to know where this whole catcher in the rye type anger comes from and how it manifests. I believe that he is more helpful to the community being studied, trying to figure out how did we get to Parkland versus putting him in the ringer for appeal upon appeal upon appeal. He may not even see the death penalty for decades now. So I think that the state really dropped the ball. However, when you have these families that are hurting this much, when you have a case this big, although it's the best move to allow him to plead, to allow him life without parole, the families need to be heard. They're not being heard in their government. They're not being heard in their Senate. So they have to be heard somewhere. So I can see why they did it.
Nima, as a former prosecutor, how much does the victim family input matter, and should it matter?
It should matter. It's very important because, look, I mean, Eklund and Kirk said it. I mean, the death penalty prosecutions, they are expensive. They are time consuming. More often than not, they don't result in the death penalty, even if there is a conviction at trial for whatever reason. There's a moratorium, the state laws change. So, but you got to take the victim's wishes into consideration, because if you believe in the death penalty, and I understand the public policy reasons why many people are against it, but if you believe in the death penalty, Ted, this is a death penalty case. He is the worst of the worst. I mean, there's evidence that he's racist, that he wanted to inflict pain. He's still violent, still in prison. So when it comes to, you know, all those aggravating factors, they are there. This is a death penalty case, again, if you believe in capital punishment.
Kirk, in your case, well, your client, Jodi Arias, was one of the most hated people on the face of the earth, at least if you listen to the social media. What happened there? The state tried twice. It was hung, and they went after her again. Why was it so difficult for besides your expert defending, to make that decision for this jury, for those juries not to be able to come to this very, very, very difficult decision?
Well, first of all, Ted, can you believe we're coming up on about 10 years since that case began? 2013 is when that case began, Ted, and 10 years later, looking back, you know, I think about the reality. Yes, there was a lot of social media. There was a lot of attacks. You're right to say that she was universally hated. And it's kind of funny because, you know, we think about some of these mass shooters. The shooting, I think it was Dylan Roof in Colorado, was going on about the same time, but all the vitriol was placed on Miss Arias. So I know how these defense attorneys feel when they're in this job, in this courtroom, looking at these families. And how her life was spared, to me, I think a death penalty case in terms of the sentencing is won and lost in jury selection, because what study after study shows is death penalty qualified juries are more likely to convict than they are to acquit. But if it's done properly, if that jury selection is done properly, and you get people that are willing to give meaningful consideration and mitigation, which is what we're going to see from Cruz's defense team after the state wraps up, if they're willing to give meaningful consideration to that, they are more open to choose life. They have to be, in order to be qualified to satisfy all those appellate standards are automatic all the way up to the United States Supreme Court, back and forth again. And Eklund's right, it's going to be over a decade. His mental health will be evaluated at the time. Nearing execution, there are going to be so many levels of appeals that are coming up. The laws might change. So it's probably more answer than your question called for, Ted. But, you know, it's one of those things where this hatred and vitriol that comes in the front end, and as Nima kind of spoke to this, that's not going to exist in the back end. And those appeals are what's going to matter. Now, we got the right jury in Arias, and we won twice. I'm proud of that fact, but I don't think the Cruz defense team is going to have that kind of luck just because of the number of victims and everything that happened in this case.
Yeah, but still, it's one thing to vote for the death penalty at the ballot box. It's another to do it in a jury room during deliberations when someone's life is on the line.